All right, Assalamu alaikum everyone. We are really excited to have WR immigration experts here with us, Naveen, Rahman, Bhora, and Avi Friedman, to help us with questions and queries regarding visa issues for our international medical graduates. Naveen is also a friend and has done this many times before for Apna YPC, and we're very grateful for her involvement and guidance. The way we are going to do this is Naveen Bhora and Avi Friedman are going to do their presentation. And once we end, we have some questions that were submitted ahead of time, and we will go through those questions. And then we will open it up for questions to be submitted by the participants. If you have any questions, please do not put them in chat, put them in the Q&A chat box, and we will answer them. If any questions are left, then we will see if we can answer them later on. Avi and Naveen are doing this voluntarily for us, so we are very grateful for your time and service. So we're going to go ahead and start.
Thank you so much, Nabira, for that introduction. I am going to share my screen now. Great. Can everyone see the screen? Okay, perfect. We've, by just way of our legal disclaimer, I do need to say that this is just informational purposes. For specific questions regarding your individual cases, please do reach out to us directly for a consultation. Just a little background on our firm. We are a California-based firm. I manage our New York office, and then we have a Boston office as well, and then Avi's based in Los Angeles. So Avi and I have actually worked for well over 20 years now, and we've been working with UPNA YPC, I think, for close to 15 years. We're familiar with the issues that you guys are going through right now. For the topics, we're going to talk about the different non-immigrant visas. These are the temporary visas, how to obtain the non-immigrant status. And then Avi will talk about consular processing, some of the issues that you may come across when you're applying for the visa. And then another big sort of topic is, changing status within the United States. And Avi will go over that with you as well. Okay, so these are the the most common visas for physicians. We're going to primarily focus on the first two. I did want to just mention the others. The O1 is for people of extraordinary ability. This may be an option for some of you once you've gone through your training and your fellowships and you have a sizable portfolio or CV with lots of publications. The O1 can be a great option. The TN is for Canadians and Mexicans. It's limited to teaching and research only, so you wouldn't be able to be on the TN for residency. The E3 is for Australian citizens, so if any of you guys have Australian citizenship, this is very similar to an H1, but there's actually a lot more flexibility in that you can extend E3s pretty much indefinitely. The B1 is something that you guys may already be familiar with and may have probably been here on a B1. It is a business visitor visa. Typically people come here for interviews or for their USMLEs. Just want to say this over and over that it is not employment authorized, so please never work on a B1 visa. Okay, so the J1, I'm sure this is something that most of you guys are going through, having matched. The J1 is the most common visa for residency. The whole process is done through ECFMG. They're the only authorized agency to support the J1 for graduate medical education. You do need to provide your USMLE steps 1 and 2 to them, the statement of need, and then they issue the DS 2019 form. This is a State Department form, and typically this form is issued around the end of April. And then you have about 60 days to then obtain your J1 J1 status. If you're going to the US consulate for your J1 visa, there is no further approval notice from immigration. You just present this DS 2019 form. The one great thing about the J1 is that the spouses come on J2 visas and they can get employment authorization. So we actually do see a lot of couples where one person's doing their residency on the J1, the spouse starts residency on the J2 with the employment authorization card. Just keep in mind that you can only apply for the employment authorization card after you arrive in the United States, and it can take several months to receive the EAD. Also, when the J1 finishes their training and is transitioned to an H1, the J2 will then lose their employment authorization. So that's just something to keep in mind with timing. The J1 will make you subject to that 2-year home residence requirement, and we'll talk about that a little bit further down the presentation. 214B is something that Avi will discuss. It's an issue related to applying for the visa at the US consulate. The J1 is limited to 7 years of progressive training. So if you are in a longer track program such as surgery, and then you have fellowships on top of that, it is definitely possible to get an 8th or 9th year extension of your J1, but you do need to show that there's exceptional need for that specific specialty in your home country. Progressive is also important because if you've been matched into a prelim program, the following year you need to show that you've been matched into categorical, and it has to be progressive. They don't want to see you going stepping backwards or not being able to proceed beyond that 1 year. Also, people may want to do research in the middle of their training, and that's typically not an option for someone on a J1 because they do want to see the progressive training every year. Timing is also really tough with the J1s because a change of status can take several months, and I will leave that to Avi to go over. The J1 is also an option for people coming for research. You can become subject to that 2-year home residence requirement while on J1 research. The skills list is specific to countries, and thankfully Pakistan is not on the skills list. So just because you're a Pakistani national coming for research, you will not be subject. However, if you do get any kind of government funding, such as a Fulbright, that will trigger the 2-year home residence requirement. In these situations, the DS 2019 is actually issued by the university or the medical center. That's where you're doing your research. It is possible then to transition from the J1 research to the J1 clinical. If you're doing this on an H1, you just need to make sure that you're not subject to that 2-year home residence requirement. And then if you're going from J1 research to J1 clinical, ECFMG will want to see that there is a nexus between the research that you are doing and the clinical training that you're going to go through. So you do need to explain yourself to ECFMG, and then they should be able to support that J1 for you. All right, so the 2-year home residence requirement means that you can't get a green card, an H visa, which is the most common work visa, or an L visa until you've actually completed your 2 years in your home country. You can get other visas. So you could, for example, if you're subject to that 2-year home residence requirement, get a O1 visa, or you could switch back to a J2 if your spouse is on a J1. So there are other options that you can go on as a way to avoid that 2-year home residence requirement, but eventually you will need to deal with it in order to get a green card. All right, so anyone who's coming to the US for training in GME becomes automatically subject. So just getting the DS 2019 issued to you doesn't trigger it, but getting the J1 visa and coming to the United States or applying for the change of status to the United States, that will trigger that 2-year home residence requirement. And then also the J2 and accompanying family members become subject as well. So if you are a subject, what do you do? So you can either go back home for the 2 years. You can't complete this 2-year requirement in a third country. So if you're thinking that you would go to the Middle East or to Canada after your residency, that's not going to take care of this 2-year home residence requirement. You can do it in aggregate. So if you're on an O1, you could plan to go back to Pakistan, every year for 2 months at a time, and then eventually show that you've completed 2 years in total. You can also, apply for a waiver. And the waiver, the most common waiver is actually done through work. It's where you are committing to working in an underserved area. The Conrad State 30 program is the most common of these, what we call IGA waivers. So every state, the Department of Health has 30 slots that they give out to physicians. And you have to show that you're going to be working in a HPSA, which is a healthcare profession shortage area or a medically underserved area. Most of these slots are given to people in primary care, but it is possible for specialists to get slots as well. But they're a lot more competitive because if there are any, then that's like limited to 5 per year. Okay, you can also get a waiver through hardship to a U.S. citizen or permanent resident spouse or child, or a persecution waiver. And the persecution waiver is very similar to an asylum application. The next visa is the H-1B visa. So some people may be offered an H-1 instead of a J-1 for their residency program. The thing to keep in mind with the H1 is that there is a 6-year limit. So if you are planning to be in training for a very long time, such as surgery, you're going to run out of H1B time. So in that situation, it's probably better to go on to the J1 than to the H1. Also, if you've used up any H-1B time doing research before your residency, that time is used up. So you might also, reach the end of your H-1B time if you've dedicated some of that to the research before your residency. The initial H-1 is given for 3 years, and then you can get another 3-year extension. It is possible to get an extension beyond 6 years, but those are limited to people who've started a green card process. There's only 85,000 H-1B numbers given in a year, but physicians who are working in a teaching hospital for residency, they're actually exempt from this annual limit. If you're going to be working in an underserved area as part of your waiver commitment, you're also exempt. But if you were here on an H-1 for residency, you were never counted towards the H-1B cap. And then if you're trying to then transition to an H-1B job with a private practice, you are subject. So what that means is that you're part of this annual H-1B cap registration. The registration happens in March every year, and all the companies, they put in their registrants for that year, and then immigration will do a random computer draw. So this year they received well over 300,000 registrants for 85,000 slots. So it's the chance of being selected are about 30%. And then if you are selected, the H-1B would then start in October. So if your training ends in June, there will be a gap, and so you would have to go home for those 3 months and then come back to the States in October to start your H-1B job. The requirements for the H-1 is that you can't self-petition. It has to be done with an employer. There is a prevailing wage requirement. If you're going to be doing your residency on the H-1, then just keep in mind that you also need step 3. The H-1Bs are really expensive. So this is part of the reason why a lot of programs don't want to do the H-1 for their residents, and they would much rather do the J-1. And with that, I'm going to hand it over to Abhi.
Thanks, Naveen, and hello, everyone. So I'm going to be talking about the 2 different ways that you have, or the options that you have to actually effectuate your status. And the 2 options are the change of status from within the United States And then we'll talk about that first. And the other option is consular processing, which means applying for your US visa at a US consular post. So let's go to the next slide and start off with what the change of status process is and what it means. Change of status implies that you're physically present in the United States in some sort of status. So you entered with a visa and you were granted status when you came in at a US port of entry. And so you can either file to extend or you can file to change status. And unlike the visa situation, the applications are filed with Citizenship and Immigration Services, which is based here in the United States. So the filing is done stateside. Most of the time, this is going to be a paper filing that gets submitted to the appropriate immigration service center. The key with change of status is that A, you had to have entered the country legally, and B, that you maintained your underlying non-immigrant status with no gaps in your status. So one of the other things to consider too is if you entered, let's say as a visitor under the B visa for whether it's interviews or such, and now you want to apply for the J1 or the H1B, timing is very important, because if you apply too soon, the Immigration Service will presume that you may have committed fraud or misrepresentation if the application is filed too soon. So normally we say you want to give it at least 90 days from the time that you were admitted and in one category before you file for another category. Also, if you enter as a visitor and you change status to the H1 or J1, later on in the future, even if the Immigration Service approves you for that status, when you go to travel and you want to come back to the United States and you apply for your US visa, a US consular officer will look at this anew. And so if they find that you committed fraud or misrepresentation, you could be subject to a permanent bar from coming to the United States. So just because immigration approves it stateside doesn't mean that a consular officer will agree with that finding. In terms of our two main visa categories today, the H1B and the J1, you can file the change of status. The key is to file the change of status if you're filing from a B to the H or a J to an H, to make sure that you're in status at the time it's filed. There is the option to do premium processing. There's an extra fee of $2,500 that the Immigration Service charges. That buys you adjudication within 15 days. Sometimes they issue a request for evidence, and then you have another, after you respond to that, they have another 15 days within which to either approve or deny the application. Unfortunately, with the J1, there is no premium processing available. So unlike the H1B, which is filed with the Form I-129, the J1 is done on an I-539, which means there's no premium. So after you have been issued your DS 2019, assuming that you're in status still, you can file the 539 application with the Immigration Service. The issue with this is the timing. When there's no premium available, let's say you're starting in sometime in June, or you've got a July start date, and you just got your DS 2019 late April, you've got the month of May and June to get this approved. And so 2 months is very difficult timing, because a lot of times immigration can take 6 months, 9 months, sometimes even a year to process these change of status applications. In terms of the change of status with the Immigration Service, they also want to see that you're maintaining your status while the application is pending with the Immigration Service. So oftentimes that means you have to file what's called a bridge application. So not only do you have to file a change of status to the J1, but you may also have to file an extension of your underlying non-immigrant status if you're here as a visitor. So timing of the application when filing with USCIS is quite complicated. We are always hopeful that at some point in the future, and there was talk about it last year, that they would make premium processing available for other visa categories besides the I-129 based applications, but we're still waiting for that to happen. So let's go to the next slide. So the next few slides are going to be talking about consular processing, and what that means is applying for your US visa at a US consular post. So this is what you would be doing if you're outside the United States. And so the obvious choice when considering a visa application is applying at the consular post or posts located within your home country. And so you can start off by visiting the Consular Post website. All U.S. consular posts throughout the world maintain websites, and they provide lots of good information about the visa application process and how to book the appointment and pay the visa fees. We provided a link here that gives you the information regarding how long the wait times are for different visa categories to obtain an appointment. But that doesn't mean how long it'll take for the visa to be issued, just when you can actually show up and apply for your visa. The other option that you can do is to apply at a U.S. consular post that's located in a third country. It's called Third Country National or TCN processing. So assuming you're in the United States, oftentimes we consider somebody applying at a U.S. consular post in Canada or Mexico. Right now, because of the pandemic, these options are quite limited, and we'll get into some more details about the limitations. But in general, the consular posts in Mexico, and there's 10 of them, they limit to renewals of same category visas. So if you had a J1 visa issued in the past and you're applying to renew your J1, that's permitted. But if you had your J1 and you obtained a waiver and you're applying for your H1B visa, generally that's not permitted. So sometimes you can get a special exception and obtain an emergency appointment for such a case. If you're a physician in an underserved area, they may make an exception if they have availability. But again, because of the pandemic right now, routine visa appointments are not available in Mexico for third country nationals. North of the border in Canada, they do accept all types of third country nationals as long as you're not out of status. Again, getting into Canada right now is quite tricky. They're one of the most strictest countries in terms of allowing non-citizens into their country. So it's very difficult to get into Canada. And even if you could get into Canada, they have very limited visa appointment availability. Hopefully in the future, and hopefully in the near future, things will improve. And so if you are here in the United States and you need to renew a visa, or you're applying for your first time visa, then maybe Mexico or Canada might be a potential option. They do have their own challenges, and it's probably a good idea to chat with Immigration Counsel or have Immigration Counsel assist you with that sort of a visa application. So let's move to the next slide. So this slide really just goes through what happens at a visa interview. And so if you've never been inside a US embassy or consulate, this kind of gives you an idea of just how it looks and how the consular officer is situated. There's this thick bulletproof glass window. There's a tray to slide documents back and forth. Sometimes they have a mic that they'll use so that they can hear you and you can hear them. But it's a very short interview. The consul has to interview sometimes hundreds of visa applications during a typical day. So they only allot a couple of minutes to the visa interview. And at the visa interview, they're doing several things. They're reviewing your online application, which is the DS-160, which you'll bring to your interview that has the barcode on it. They're conducting the interview. This is the verbal interview. There's questions and answers. They're judging how you answer, how you respond. They're very good at judging, and they're trained in interview skills. And so they're listening to your answers and how you're interacting, just to get a sense of, are you being truthful, forthright, and sincere in your responses. The documents to them are sort of secondary. They don't, as well prepared as you are and as much documents as you bring, they may not look at a single additional piece of documents besides your initial visa application in DS 2019, and they don't have to look at documents. That's at their discretion. So a lot of times we hear from our clients that, oh, the consular officer didn't look at any of my documents, and it sometimes does occur. They're more interested in hearing from you and hearing your responses to their questions. During the interview, they're taking notes on their computer. They're running necessary security checks. For the J1 visa, they're evaluating, what are your ties back to your home country? What is your intent upon completing your residency program in the United States? And it has to be that you do plan and you intend to return back to your home country after completing your training. If you say, I want to live the rest of my life in the United States, there's no way you're going to be getting a visa. As I mentioned, consular officers are very skilled in the interview process. Any misrepresentation or lie is material and will likely lead to a denial. and possibly also it could lead to a fraud finding, which, as I said, could be a permanent bar to future immigration benefits. All right, so let's go to the next slide. So during the pandemic, what we've been seeing is that many of the U.S. consular posts throughout the world have been closed for what they deem routine visa services. And so to be able to secure an appointment at a consular post requires that you apply for an emergency appointment. So you can see the Department of State just recently released a new some news about reopening and what their priorities are. And basically what they've said is they are starting to phase in the processing of some routine immigrant and non-immigrant cases. And really it just depends on local country conditions. So it depends on their staffing levels, the local conditions in terms of quarantines and lockdowns and travel restrictions, et cetera, really is impacting their ability to conduct visa interviews. They haven't gotten to the point where they can do this sort of virtual types of interviews. They still require most first-time visa applicants to come in person for an in-person interview. If you do try to schedule an appointment and you see that you're getting caught in the backlogs, first, what you want to do is that, keep checking the online appointment system, book the first available appointment, even if it's as far out as October, November, December, just book it. And then once you've booked your appointment, the next thing you can try to do is request an expedite. So let's move to the next slide. So with the expedite, what you're doing is outlining the reasons for your emergency travel to the United States. So here, let's say you're a J1 or an H1B for residency, you would say my residency is starting July 1st. My appointment is October the 1st. I need to start on time. And there's lots of American patients that are relying on the residents for medical care, and I need to be there on time. And so normally they will consider that and weigh it and balance it against the scheduling. Most of the time we find that these expedite requests for medical residents get honored. They're very attuned to trying to expedite for physicians coming for residency. For other visa categories, let's say you just want to come for interviews, that's going to be a harder sell for an expedite, but you definitely can try. And definitely when you're within 60 days of your start time, they should be considering that expedite request. Now remember, the expedite relates only to your visa interview date and not necessarily how long the rest of the process will take, whether it's visa issuance, administrative processing, getting your passport back. So the expedite is how soon you can have your interview with the consular officer, not how fast your visa will be issued. So we can go to the next slide. So the bane of immigration attorneys and visa applicants is administrative processing, which is this mysterious term that Department of State created, but basically covers a whole gamut of different delays that can occur in the visa process. Most of the time, these are checks that are conducted by the consular officers, and it could be anything from an investigation, an advisory opinion, and security advisory opinions or security clearances. And so, the consular officers, as they go through the application, they're typing things up, they're checking on their databases, and sometimes based on what they see, they have to run various clearances. It can have to do with a common name. So if you have a very common name like Muhammad Ali or Muhammad Khan, it's almost a certainty that you're going to be subjected to a lengthy security clearance, because in their database, they show somebody with that name and they're not able to differentiate the person. And so they have to run various clearances, and that gets done back in Washington, D.C. at the visa office, and they vet it out to various other government agencies. If you have any type of criminal history, whether it's an arrest, even if the arrest ultimately got dropped and you never got convicted, or if you do have a conviction in your history, this will cause delays as they request the records from you, or from, if they occurred in the United States, they need to get those records. Also, if you're from a certain country, there's a potential for additional security checks. If you have a history of any problems with alcohol or drug use, that could cause delays and or denials. And the issue is that the consul doesn't tell you what type of check you're being subjected to. They'll just say, we need to do additional administrative processing, and we'll let you know when we've completed the process. It could be as quick as a few days, sometimes a few weeks. And sometimes it takes many, many months, and I have seen some clearances take years and some don't ever resolve. So, you know, you just have to be aware, and the key really is to try to apply as soon as possible. So in case that administrative processing occurs, that gives you a little bit of leeway for that processing time. So let's go to the next slide. So if you are subject to administrative processing, what can you do? There's not too much you can do, but there's definitely something you can try. The first is you can try to call the National Visa Center, and we've listed the phone number there. They really don't give too much information, but they can at least tell you if your case is still pending. They won't tell you when it will be resolved, but they can check in their database if the case is still ongoing, administrative processing. Sometimes they might give you some good news and tell you that it's been approved. And so then you can reach out back to the U.S. Consular Post and say, oh, I realize, you know, my case has been approved. I'd like to turn in my passport. Oftentimes when they've got lots of cases, sometimes cases get overlooked. You can try reaching out for congressional assistance, have your hospital, normally if they've got connections with the local Congress folks, so they might be able to put in an inquiry with the U.S. Embassy or Consulate to find out the status and try to request an expedite. Definitely reach out to your APNA representative. Sometimes they have some political assistance that they can provide and try to unjam the case. And you can always, when you're at the visa interview, you can always request that they expedite your case just in case it is subjected to administrative processing. It's good to have a letter from your program explaining the urgency for you to start, and cite to some statistics about the patient care in your local community and how important it is for you to start on time, and what the detriment would be to the local community if you missed your start time. Last but not least is what's called mandamus, and that's basically suing Department of State to try to get them to take action on an overdue case. It doesn't get them to approve necessarily, but it gets them to make a decision. So hopefully it would be an approval, but it could also lead to a denial. But it does take quite a bit of resources and time to sue the Department of State, but that is something that is possible. So we'll go to the next slide. So, what happens when you encounter some issues at your visa interview? And so, if it's in the unfortunate event that you do get denied, what is the process and protocol to follow, and how to try to resolve that? So number one, a consular officer is supposed to provide you with a denial notice in writing for the reasons for your visa denial. Oftentimes it's a form letter with a little box marked down, what ground they're denying you on. Normally in a J1 context, they're denying under what's called 214B. They just don't believe that you have strong enough ties back to your home country. They don't believe you're going to return back to your home country after completing your training. That's the most common visa denial in the B visa context and the J visa and student visa context. If you happen to know the officer's name or the window where you were at, jot it down. Go back and write down the questions you were asked and how you answered. So, we recommend you can consult with Immigration Counsel and we can review what happened and try to evaluate, look at the reason for the denial. A soft denial is 221G. That's where you forgot to bring an important document with you to the interview. So for instance, let's say you didn't have your original DS 2019, you didn't sign it, or you didn't have it with you, and you came in with everything else, they would give you a 221G letter saying, submit your DS 2019 and we can process your case to completion. So that's sort of a soft denial versus a more serious 214B denial. You can sometimes, when it's a very egregious denial and the consular officer didn't follow the protocols, we can ask a supervisor to reconsider the visa application. Oftentimes they might not reconsider, and they may say, well, if your visa applicant wants to reapply, you're welcome to do that, but that does require paying new visa fees. But sometimes when it is a pretty serious mistake that the consul made in a particular case, then a supervisor or manager might consider the request for reconsideration. Oftentimes we get asked if I've been refused my visa, and I still have my valid visitor visa, or I'm eligible because of my, if I have dual citizenship, to try to enter on the visa waiver, is that possible? And so if the consular officer did not cancel out your valid visa, in theory, it is possible to re-enter. You should anticipate that you may get asked lots of questions or be referred to secondary inspection by Customs and Border Protection officers at the U.S. Port of Entry. The issue with trying to utilize the visa waiver program is that once you have a denial on your record, you have to go back in to the online ESTA registration and update that denial. And normally once you've been denied, they will cancel out your ESTA registration. So visa waiver is probably not going to be an option. You know, we keep saying this, but timing when you apply for the visa is critical. Trying as soon as you have all your documents ready, scheduling your appointment, trying to get the soonest available appointment, and if necessary, trying to gain that coveted expedite appointment. If you're in the United States and you entered with a valid J visa or the H visa, and your visa is up for renewal, the tough question always that we see is, well, I want to travel, I want to go visit my family, there's a big event that may occur, whatever it is, there's, you know, travel always comes up. And so, you know, we can't necessarily decide this, but discretionary travel is an issue. You have to understand, especially with the J1, consular officers have discretion. Just because you were issued that first J visa and you got it, and you were, you know, you finished a year or two and you want to travel for vacation or for whatever it may be, there is a risk that a consular officer could say no. There's also a risk that you could run into administrative processing. Even if the first visa interview went very smoothly, doesn't necessarily mean that your next interview won't have delays involved. And you know, the same goes for the H-1B. Normally they're not going to be denying you on a 214B grounds, but there could be potential delays for one of those types of administrative processing. So that's something you definitely have to consider in a travel scenario, and that's something you could talk to your program about and talk to immigration counsel about the risks of traveling. So we can go to the next slide. So Naveen, you want to take the questions, start with those?
Thank you, Naveen. I just wanted to add one thing. With the visa, that just enables you to travel into the US. So what you'll actually see with the J1s is the DS 2019 is only issued for a year, and every year you'll get another DS 2019. And that's really the only document you need to be able to continue living and working in the US. If your J1 visa sticker expires, there's no requirement that you get a new visa to maintain your J1 status. The visa stamp or sticker is really just to enable you to travel. So we do say think really long and hard about traveling, especially now with the pandemic going on. There are also travel restrictions from certain regions. If you're going through Europe or the UK, you can't come directly to the US at this point. You do need to spend 2 weeks in a third unrestricted country. So there's a lot to think about when you are considering discretionary travel. So you can't have two different visa statuses at the same time. So can you apply for the J1 or the H1? You do need to try one, and then if the H1 doesn't happen, then you could go back and try for a J1, but you can't do both at the same time. You can't hold two different visa classifications at one time.
And the concern would be with the J1 too, if you went for that first and you got approved, you would be subject and couldn't do the H1 as well. So, you know, normally if you can qualify for the H1B, that's going to be the better choice if you can complete your program within the 6 years.
Passport expirations and renewals. So this one would mean that you provided one passport when you were doing your DS-160, for example, and then you have a new passport by the time you go to the interview. Avi, do they do another DS-160 with the new passport number, bring both to the interview?
I think I would just update the consular post with the new passport information. So if you're undergoing administrative processing, you know, reach out and say, you know, because it's been going on so long, my passport expired, I got a new passport, here's the new information. Maybe send the scan of the biographical page with the new information. But I don't think a new DS-160 would be required. I guess it's always, depending how long it takes, it's up to the consular post to determine if that would be, but I don't think that should be an issue. And then once the clearance and everything's been settled, then you would turn in your new valid passport. I don't think that should be much of an issue.
One other thing to keep in mind, not so much for J1s, because when you actually enter on a J1, you're admitted for what's called duration of status. So as long as your DS 2019 is valid, you're in status. But for everyone else on an H1B, or you have an actual admit until date on your petition. And so sometimes your petition may be valid for another 2 years, but your passport's expiring before that. And so just to keep in mind that the Customs and Border Protection will only admit you for the duration of the passport and not necessarily the duration of your petition. So every time you enter the United States, you need to be really careful and diligent about checking what your I-94 record shows on the Customs and Border Protection website to make sure that you are in fact being admitted for the time that you're expecting. We actually see this a lot where people didn't realize that their admission was cut short because their passport was expiring. They went ahead, they renewed their passport, they thought they were fine, but their I-94 had actually expired a year ago or something. So that can be a big problem.
Yeah, definitely. For both visa applications and entering the United States, they prefer, the rule is that the passport should be good for at least 6 months past the time you plan to be in the United States. So, keeping an eye out on passport expiration is very important, and trying to plan for renewal as far in advance as possible.
So one of the questions is on the H1 and not having your CS step 2 exam. So it's been fine. You would just file the H1B petition with the notice saying that the exam has been suspended, and immigration has been fine with that one. Staying longer than in the original stated intent on the B. So Avi, I'll let you take this one.
So, we've been seeing this quite a bit over the last, we're already going on a year now, where people came in as a visitor, whether for tourism purposes or to attend interviews. And just because of the pandemic and shutdowns with airlines and flights or health conditions in the countries overseas, people decided that they wanted to stay longer than the initial entry. And so going back to the first thing we talked about, filing with immigration, it is possible to file an extension as long as you're filing it on time. There are procedures to file late filings, but that gets quite complex. But yeah, you can file. It does boil down to what was, intent is personal. It's all what's in your mind at the time you came into the United States. And how you demonstrate it, well, if filing with the Immigration Service, it's all done with paper filing. So you have to be able to explain to them in writing, this was my original intent, and these were the reasons why I'm not able to comply, and I need longer time in the United States. And maybe that you decided to file the change of status because of the delays in visa processing at consular posts abroad. We have been seeing a lot more filing stateside because of that. But as I mentioned, it is a lot more difficult because you do have to create that bridge application to always maintain your underlying non-immigrant status while everything is pending. And so the Immigration Service got inundated with applications over the last year. Processing times are quite delayed. We're just now starting to see adjudications from cases that got filed, in last year, February and March. And it's really easy to get caught in a mistake if you file these applications on your own. There's a lot of loopholes and traps that one could get caught in if you don't do it properly. Also, if you file the extension and then you leave the United States at some point to go and apply for your visa, as I mentioned, a consular officer can also look at it, and they're going to say, oh, you told us on your DS-160 you only plan to go to the United States for a month or 2 months, and you were going to do interviews with these particular hospitals, and you stayed 9 months. What was going on? And so they always look at it with a presumption that somebody violated status, and they always think people that come to the United States and stay long worked illegally. So the burden is on you as the visa applicant to be able to prove to them what your intention was at the time, why your intent changed, and how you supported yourself during your stay in the United States without working. So you've got to, oftentimes they'll, have your bank statements available to be able to show you had enough savings and this is what you spent your money on, how where you were staying, if you stayed at a friend's place or you rented a place or stayed at a hotel, whatever it is, to be able to prove and be able to show an itinerary and prove that you actually did these things. So have letters confirming that you attended the interviews and that you did whatever you told the officer or the immigration service that you were going to do. So being able to prove, all these things that occurred is very important.
Should we take some additional questions?
Yes. Well,
Yeah.
thank you so much, Avi and Naveen. Sounds like we also need good immigration lawyers. So if anyone is struggling, you can reach out to WR Immigration, and I hope at the end we have some contact information for you guys. We are going to have a couple more questions. I think most of the ones I had submitted you have answered, and I really appreciate that. One of the questions is about being able to do observership or hands-on experience on visas. Some of our graduates are doing research, J1 research, and the question is, are they allowed to have clinical experience or patient care during the J1 research visa?
So it's my understanding that you can't actually touch a patient unless you're a medical student. So once you've graduated, I don't think you would have permission to do anything that's clinical in that respect. And even for observerships, you really are that fly on the wall, that's observing what's happening. You can't actually do anything directly with the patient.
I think unless the research actually requires you to be part of some clinical research that requires patient contact, I think people are asking about outside that. So just to clarify, what Naveen is saying is that you're not allowed to do anything other than observership beyond your institute where you're doing research, unless that involves clinical care. I have a question actually for Avi. Avi, you had mentioned about intent with the J1 and that they really look for what about H1B for the interview?
So very good question. So the H1B is a dual intent visa. So proving your ties back to your home country shouldn't be a consideration. So if the consul asked, what are your long-term plans? I always, like to say, my H1B is approved for this amount of time, and that's how long I plan to stay in the US. But, if you did have a family member who's a US citizen and they sponsored an immigrant visa petition for you, which can take 14 years or longer, or you had filed for a green card in the past, it's not an issue with the H1B, but with the J1, it's a definite issue. It's funny because with the J1, you become subject to the 2-year home residency requirement. So there's no way you can proceed to a green card without a waiver, but nonetheless, consuls still look at all the different factors. Have you taken any steps towards green cards or staying, have you stayed too long in the United States? And really, what are your ties back? What is your intent? How do you plan to use your medical training that you obtain in the United States? The whole point of this J1, it's called an exchange visitor visa. The whole point is you come to the United States to learn skills and bring those skills back to your home country. That's why they created the J. So you have to be able to show how you're going to be complying with that and really how your training in the United States will benefit you, not to gain a career in the US and a life in the US, but how that's going to help you when you return back home.
Okay, thank you, Avi. Any guidance for graduates who are doing observerships or going back and forth on their visitor's visa, the B1, B2, as to when they do apply for J1, how do they explain that during the interview? Or should they explain it at all?
I think you have to be ready to have documentation of how you spent your time in the U.S. Doing the observership. So we have seen people being asked to present letters from the people that they were doing observerships with. So it has to be a really clear timeline or itinerary of the different observerships that they had. They can also ask how you supported yourself during that time. Did you have the means to, pay for your room and board? Because these are all, of course, unpaid.
Okay. And any particular ways that actually, other than the walk and talk, how do we show ties to the country? I know some people take bank statements. Any specific guidance, or is it just up to the immigration person to make that decision?
I mean, it's always tough when, most medical residents are still young and may not have lots of ties. So the other thing to be able to show is your family's ties. So if your family's well established, have a comfortable lifestyle, have bank accounts, I say take pictures of your home, show a picture of your house and your cars and your furniture. And if you don't have a significant bank account yourself, your mom or dad's bank account and property documents. If one thing that they look at is, have you traveled to other countries? Have you gone as a tourist? Did you visit other countries and come back? So they're evaluating all these things. And so that, on the one hand, consuls know younger people may not have strong ties, but they're looking at, mom and dad, brother, sister, what visas have they had? Have they always complied with immigration status? If you've got 4 or 5 brothers and sisters and they're all US citizens and they started on J's, that's not going to bode well versus, they did training in the US and came back, then that's going to be helpful. So it's on the DS-160, it asks about family members in the United States. It asks about your immediate family. And so these are various factors that the consular officer will be evaluating.
Okay. This is, I think, a good question. Can I mention one country consulate on the I-129 and then apply visa from a different country?
Yeah, there's no problem with doing that. It used to be an issue, but in today's climate, there's what's called PIMS. That's the Petition Information Management System. So regardless of whatever consular post is listed on somebody's approval notice, a consular officer has to verify the information in their database anyways. So you can take an I-797 approval notice, even if it shows, let's say, Islamabad on there, and apply in Karachi or apply in the U.S. Embassy Ottawa. It really is not relevant in today's climate. It's sort of a remnant of sort of the past system where they actually would fax approval notices to the consular post you listed. But in today's age, where everything's now done through their online databases, it's not so relevant. So it's not too critical.
Okay. And similar question about entering as a B2 and then doing an observership. I would assume that when you're interviewing later on, you just have to show intent. Is that right?
Yeah, I agree. And the only other wrinkle here, I guess, to mention is that Canadian citizens most of the time are visa exempt, except for the E-visa, investor or treaty trader, or the K-fiancé visa. So Canadians normally wouldn't have an actual visa in their passport. So let's say they're applying for their J1, they would present the DS-2019 at a U.S. port of entry, and Customs and Border Protection would make an adjudication there on the spot. They don't actually have to go through the U.S. visa process and show up at an embassy or consulate.
Great. Well, I think that's where we end. Thank you so much. This has been very helpful. I've learned quite a few things because clearly a lot of things have changed since I came to the US. I think I know everyone is very anxious. And if you start running into trouble, UPNA is available to help you. Dr. Fateh Shahzad is co-chair of the UPNA Advocacy Committee, and he's here. We have great lawyers like Naveen and Avi who can help you if you hire them for your services. And then I think most of all, talking to other people, but not focusing on the negatives and remaining confident and hopeful, and during an interview would help you a lot. Like Avi said, I mean, the interview is about 2 minutes and they really just train to look at you, listen to your question and answers, and see how you're responding. So I don't have any last comments from anyone.
This is Dr. Fateh Shahzad. Thank you, Naveen and Avi. It was very comprehensive information. And from the co-chair of advocacy, I thank you from UPNA. One thing I wanted to add to you all, as well as to the participants, that we have around 250, 249 potential candidates this year for H1 and J1. So we got their kind of intent where they're going to go to Karachi or Islamabad. We have contacted the visa section, and we have provided the potential number of candidates that might need expedited or emergency interview appointments. So they will accommodate them end of April, May, and June. So that is good news that they will accommodate all those J1 and H1 and J2s and H4s. Thank you.
That's fantastic. All right, so has UPNA requested that anyone applying reach out and provide their information so that you can relay this to the consulate?
We have given them their names as well as who will be applying in Islamabad, who's going for J1, who's going to Karachi, who's going to for H1 and J1 there and H2 and H4. So we have provided them a list. And of course, they will have to upload DS 2019 and contact letter whenever they ask for expedited interview.
And one of the things I think Avi pointed out that, and Dr. Fateh Shahzad also told me to bring up, is that once you get your appointment, don't be worried if the interview is, say, in March or April. Apply for an expedited interview based on the need to start your residency program on the start date. So don't panic. And just apply for an expedited interview. That doesn't mean the process will be done fast. It's just that you might be able to get a sooner interview. So okay, so we're going to end here. Again, I really appreciate everyone taking time out for this very important topic, and we hope to see Avi and Naveen again in next year. We really appreciate you sharing all the information voluntarily. It's just really very kind of you. Good luck to all the people who are applying, and thank you very much.
Thank you.
Thank you.
Yeah.